Hi, Attorney Jim Selbach. Welcome to the Selbach Law Offices. This video is designed to introduce you to our system for automatic stay and discharge injunction violations and our approaches and our procedures, since you'll now be referring those cases to our office. So let's first take a look at our approach or our philosophy to these cases. Now, I was a practicing bankruptcy attorney for over 32 years, offices across the state, and I use what I call the old school method, which means there's a violation, you send a letter to the creditor, you try calling them, you try doing those things to stop the illegal activity, and most of it is very unsuccessful. At least that was my experience. Our approach is very differently. We use the mechanism that the Bankruptcy Code has provided us, which is motions for sanctions and violations. And that's what our approach is based upon, what the statute provides. So the first thing that we should talk about is, do you have to warn a creditor before filing a motion? And a lot of people think that, but that's not what the statute provides. Remember now, when a violation has occurred, the creditor has already been notified. So I'm not sure what the warning would be. You violated the stay, please don't do that again, or please stop doing it on multiple occasions. There's no obligation to provide any kind of warning. You won't find that in the statute. Here's what former Chief Bankruptcy Judge Stephen D. Gerling had to say about this. He said, "It's not the responsibility of the debtor to take action that ensures that she receives the protection of the automatic stay. Rather, the creditor bears the burden of seeking relief from the automatic stay before taking any post-petition collection efforts." We had a case in which the defense was, hey, you have to fire a warning shot across the bow before you file a motion. And here's what Judge Gerling had to say about that. Such a requirement would place an unreasonable burden on the debtor to forewarn the offending creditor to cease and desist before the debtor's counsel could reasonably file a Code Section 362H motion. So our approach is, we don't send warning letters. If there's been a violation, we either file a motion, or if we've had a history with that particular creditor, we may contact him directly. So the second thing is, because we've been doing this since 2006, we have a lot of contacts. You know, we've litigated cases with a lot of law firms and a lot of creditors, and they know who we are, and they know we're serious. So with some creditors, we can simply draw the motion papers up without filing them, email them to our contact, and we settle the case without ever filing. Now that took years of litigating and trying cases to make it known to them that you got to take us seriously, because if you don't settle with us, we will file a motion. So we file a motion if we don't know the creditor. If we have a contact that we know will settle with us, we'll do it that other way. 99% of these cases are settled. Why? A couple of reasons. There's really no defense. On an automatic stay violation, you just have to prove the creditor had notice and the creditor did something. So there's no point in trying to defend it. And attorney's fees are granted to debtor's counsel. So if they did fight it, the attorney's fees would just get larger and larger. Third, our settlement demands are very reasonable, and creditors know this. So it's in everybody's interest just to settle the matter and move on. Okay, so how are our procedures? What will you have to do to refer these cases to us? Number one, we want you to know we do all the work. Now, if you have a client who comes in and has got a violation, normally you have to try to contact the creditor or the attorney to get it stopped. With us, it's just a handoff. We don't want you to do anything. You just provide us the basic information. We determine if there's a violation. We call the client. We file the motion. So this is taking a lot of work off your desk. You're too busy, drafting petitions, etc., rather than trying to chase creditors around who violate the stay. Okay, so what are the referring procedures? There's only a certain amount of information that we need, and you can get it to us in a number of ways. You could mail it to us at our office here in Liverpool. You could email it if you wanted to. The best way, however, is with our website. If you go to selbachlaw.com, at the very top, there's a tab that says Attorney Referral. If you click on that, you get this fill-in box. This is the basic information we need. We don't need anything else. And then at the bottom, you can upload whatever documents you might have, a bill, a letter, a garnishment, whatever it might be. We get it, you're done. You can fax it to us. We do have some attorneys that fax us this information. So, after we go through the referring procedures, what happens next? After you've referred that case to us, what do? Well, the first thing we do is we call the client. We discuss who we are. Sometimes it's helpful if you call first to let them know we're calling, but that's not really necessary. We will call the client, explain what we're doing, what we can do for them, and what documents they need to sign to bring us into the case. There's a retainer agreement, and there's a fee-sharing notice. We share fees with your office, and the ethic rules require that a certain form be filled out to be signed by us, your office, and the debtor. So the retainer agreement and the fee-sharing agreement go off to the client. We either email it or we mail it to them. We send you your copy of the fee-sharing notice. You simply have to have the lawyer sign it, stick it back in the mail. Then the next thing that happens is we send you a check, and we send the client a check. Clients are very happy that someone's doing something about this violation, but they're even more happy that they're getting money. Now, one of the most important things to remember, and I can't emphasize this enough, is it's very important at your end that you advise the clients of their rights. I'm never amazed at debtors that will pay debts that are in their petition. And sometimes they won't even call your office. And I'll ask them, why did you do that? I didn't know, I thought it didn't go through, I thought this creditor wasn't listed, so they were calling me, so I paid them. The whole idea of this is to prevent that from happening. We don't want our clients to be paying debts that are discharged in their bankruptcy case. So, our procedure is this. We have a pamphlet here, and hopefully by now you've received your supply of pamphlets. And what this does is it goes through and explains all their rights, what to do if they get a call, what to do if they get any kind of documents in the mail. But at your end, it's important to give them this every time. Now, some of our offices will give it to them at the first meeting, sometimes when they come in to sign. Other law firms, and we have 18 law firms that are currently referring cases to us, will give this to them at the 341 meeting. But the important thing is to let them know, look, the automatic stay protects you, but only if it's actually enforced. So if you get any phone calls, if you get any letters, if you get any bills, if you get any legal documents, you need to send them to us. Now, in the beginning, the client will probably send the documents to you, and then we'll get the referral and we'll talk to the client. After that happens, if they get an additional violations, they usually send them to us because they know who we are. But in the beginning, this tells them to send it to you, and then you send it on to us. So that's the procedure, that's our policy. Again, welcome to our office.